Hello, I'm Mike Hackard. I'm the chair of Hackard Law, a law firm focusing on estate trust and elder financial abuse litigation in California's major urban areas. This is Hackard Law's podcast. It starts here. This is a July 2017 podcast featuring Dave Jones, one of the senior litigators at Hackard Law. We're going to discuss how we approach capacity issues in the California Superior Courts. Welcome, Dave.
Hi, glad to be here.
Glad that you're here. So let's just start with a little background. Where were you born?
I was born right here in Sacramento, actually.
Okay, and where did you go to school?
Oh, well, went locally to El Camino High School and then went off to UCLA.
I was a local boy through and through. After college, what kind of work did you engage in?
Well, a bunch of different things. It eventually ended up in IT work, doing consulting for companies across the country, and traveled around and did that, and eventually decided to go to law school.
Okay, and what made you decide to go to law school?
Well, it was seeing. Actually, I was working for you back in the day, and in the IT field, and seeing what you were doing with the pharmaceutical litigation. I thought, sounds pretty fun, and decided to apply to law school, and got in, and got a pretty good deal out of it. So I went.
I remember you got a full ride, didn't you, into law school?
Yeah, all my tuition was paid for. All I had to do was maintain a 3.0. It seemed pretty easy, and so I took it.
Not bad. So. I'll ask, is it still fun?
Oh, yeah.
It's still fun.
Getting paid to argue, it's great.
Yeah. So what was your first job after law school in the law?
Got into the public defender's office in Tulare County.
Okay. Did that give you an opportunity to try cases?
Oh, yeah.
Okay. And jury cases?
Yeah, they were all jury trials, and I was doing them within a couple months of being hired.
Did you like that?
Yeah, it was a lot of fun. You know, getting a case and going to trial within a month and a half it's fast.
You wish you could do that now?
Potentially. I mean, I like fighting for the people, the underdogs. So, yeah, and for the most part, when you're being accused of crime by the cops and they've got all the money behind them, you're definitely the underdog. So I liked that a lot. Just doesn't pay that well, and when you got a bunch of kids and a family to support, it's tough.
Yeah. Okay. So today we're going to talk about some capacity issues, as we mentioned, and let's just start with in June of this year, you helped to teach a course at Stanford. Can you tell us a little about that?
Sure. I got asked to talk about capacity and how psychiatrists and other medical professionals fit into our work in the courtroom, and specifically how somebody becomes a medical expert to testify in front of a court. And
what group did you speak to?
This group was a seminar put on by the Veterans Affairs of Palo Alto and Stanford Medical Center. So it was a group of psychiatrists, psychologists, and neurologists from Stanford and the Veterans Administration right in that area.
Okay, and did you make a presentation?
It was a full day deal, and I gave a 1-hour presentation in the morning, and then in the afternoon we broke off and created a mock trial for the doctors so that they could see what they would actually do as experts in court. And so I took one expert and examined him in a direct exam, and then the other attorney cross-examined him, and then I got to cross-examine the other expert as well.
Yeah, you're doing what you love, I know at that point. So, what is the definition of capacity?
That's a tough question, because capacity changes depending on what we're talking about. There's different levels of capacity. There's, the low end, strangely enough, is marriage. So you don't need a whole lot to be able to say, I do, which I guess keeps Vegas in business. And then you've got the high end of the spectrum, which is the capacity to contract, which takes a lot more capacity.
How about the capacity to make a will?
That's in the middle. probably toward the lower end of things, but it's a little bit higher than to marry, but lower than to make a contract.
And is it equal to that which is required to make a trust, or is it different?
No, it's different. To make a trust is basically you're making a contract. The contract's basically with yourself in most cases when it's a revocable trust. So you need to have the capacity of the contract to make that trust. But the courts have said that if all you're doing later on is changing who gets what, you're just amending your trust to say, instead of my son getting this, I'm leaving this to my daughter, then you need the same capacity you would have to execute a will.
And I know you've been looking at one thing recently, and that's the capacity to make a durable power of attorney. So what would you add as to that?
Well, I think to make a power of attorney is actually the power to contract, and that's very high. I mean, you're basically giving somebody absolute control over all your assets, which is that's serious, and you need to have a very high level of capacity to understand that.
So we're going to look at when someone is alive, how do you determine if they have capacity?
Well, and this is where the psychiatrists and neurologists come into play a lot. If somebody's alive and we have a question as to whether or not they have capacity, the easiest thing is we send them out to a psychiatrist and have them evaluated. They can give them certain tests, talk to them, review medical records, and get a whole picture of this person's understanding as to what it is they want to do, whether that's to make a trust or leave something to somebody in a will.
And how can family members help assist in that process?
Well, if your family member's alive and you're wondering if that person has the capacity to create a will or a trust, I would say the best bet is to talk to a psychiatrist or a psychologist or a neurologist, somebody who cares for that person, knows their history, and can give them the required tests to find out whether or not they have capacity before you go to the attorney to have that document drafted.
So I can't help but do this since I know about this. Oftentimes, I've never seen, and we have never seen an attorney who did a will or a trust that said that his client didn't have capacity. Now, why would that be?
Well, obviously, if you go to an attorney and that attorney drafts a will or a trust and has the person sign it, and then they later on say, well, the person didn't have capacity, they're basically saying they committed malpractice. So no attorney's going to do that, because at that point their insurance isn't going to pay for it and they're going to be on the hook. So, obviously, if an attorney is present and they have somebody sign a document, they are going to say that person had capacity.
Okay, and I know you've litigated in this area many times. So can you tell us any stories, by omitting a few names, but of how you deposed attorneys, or maybe even how you examined them when they were on the stand with regard to this issue?
Well, sir, it varies by the attorney, right? I mean, some of them do a better job of determining whether somebody has capacity than others. Some of them will actually ask appropriate questions, actually go through the probate code requirements that are laid out by law as to whether somebody has capacity. Some of them actually do that. Some of them do a very good job of it. Others of them just seem to say, well, I can just tell. I can tell when somebody has capacity. And that's where you get into trouble. When somebody doesn't actually go through the steps and make sure that that person has each one of the required elements for capacity for this type of contract or will or trust, that's where they get into trouble.
Okay. So I know that you try cases, and you have a number of cases where the person who made the will or the trust is deceased, and at that point, what do you do to go and try to determine if he or she had capacity?
Well, that gets a little bit tougher, and that was the bulk of what we discussed at that Stanford seminar, because basically when you're getting a psychiatrist or a psychologist or neurologist involved in litigation, it's because somebody's contesting the will or trust, and the person's at this point deceased. And so the psychiatrist can't just go out and talk to that person and say, do you understand what you did here? They actually have to get medical records, review all the medical records going back years, try and figure out from the notes the other doctors made whether or not an evaluation was actually made for this particular issue, or whether they have to try and read between the lines and decide whether that person had capacity. And what the psychiatrists and neurologists have told me also is that they like to go back, and if there have been depositions taken or other sworn testimony by family members or friends, they like to read all of that, trying to get information from those people as to, well, how did this person behave? Were there changes over the years, or was it, or was it a constant decline, or was it steady over the past few years?
And is capacity, if there is capacity, is that it for any estate or will litigation?
No, capacity is only one part of it. Somebody can have capacity and still be subject to what's known as undue influence. And basically what that means is they rely on other people to such an extent that when that person tells them they should do something, they just do it, relying on that other person's statements and beliefs instead of thinking it through for themselves.
And have you tried some cases of undue influence?
Yeah, we have. And we try these cases. Usually they go hand in hand. Usually we try undue influence along with lack of capacity, because oftentimes there's both. I mean, somebody can have no capacity and be unduly influenced, just like somebody could have capacity and yet be unduly influenced. So we try them both at the same time most of the time.
Now, that reminds me a little of a case you tried earlier this year where there was an issue of capacity and also undue influence, and it was a jury trial. But tell us a little about that in broad terms, and what kind of action did the court take with regard to determining capacity?
Well, capacity is an issue that the court decides. It's not a question for the jury. So in this case, we had capacity question and undue influence question. The jury gets to decide undue influence. So in this case, we presented all the evidence. We convinced the court that they should hear the evidence at the same time as the jury, and they could make their ruling while the jury was out, and the jury could make their ruling while the judge was giving us his ruling on capacity. And the way it ended up was the jury found there was undue influence and gave our clients a certain amount of money for that. And then the court ruled that the decedent, the testator, had lacked capacity as well, and threw the will out altogether, in which case our clients ended up actually getting a little bit more, because it then split 3 ways instead of more ways under the will.
Okay, good. Well, that's probably, we've covered enough ground today on capacity. I'm certainly glad that you're so active in this area and so capable of being able to teach in it. So I want to thank you, and we'll talk again.
All right, thank you.